For today's story, we are dealing with a reminder that yes, the United States government does lose in its own courts. It's not all fixed. Things do happen where you get completely destroyed, as the United States of America did in the case of Shelby Petties. Now, Shelby over here did some bad things. They did some bad things in relation to some prurient offenses that they were charged with, failure to register as a prurient offender, some other things like that, right? So they're not necessarily the greatest person. They might have violated the law. Maybe they violated the law, maybe not. But, you know, the United States government just got their ass handed to them. They got their ass handed to them because Shelby over here decided to appeal, and they won. And then the U.S. government's like, oh, but we're sad. And then they were like, oh, we're so sorry about your sadness. Watch us not care. All right, so let's get started with this. Okay, so Shelby over here was charged with three different sets of offenses. Okay, so one of the offenses dealt with so there was a plea issue that dealt with kidnapping. Okay, and so that's not great with the kidnapping. Two separate kidnappings apparently, but they were charged with committing a crime of violence. Okay. That was the problem. They were charged with committing a crime of violence, the specific charge, right? So they were charged with some offenses for not registering as a prurient offender, not filling out some stuff. And also, there might have been a little like kidnapping in the past, but they're being charged with crimes of violence, okay? So they reach a plea deal with the U.S. government, says, I'll plead to the crime of violence thing with a right to appeal, because I don't think that qualifies as a crime of violence. So I'll plead guilty, but I want the right to appeal. In exchange for which, you're going to drop the other charges. The U.S. government says, okay, fine. We'll drop the failure to register thing. We'll drop all that stuff, right? And you can appeal the fact that kidnapping is not a crime of violence. All right, so they dropped count 1 and 3. The district court accepts a plea on count 2, the crime of violence thing, and sentences her to 96 months of imprisonment and 10 years. Okay? So she reaches a plea deal, says, okay, I'm going to plead to this crime of violence thing for the kidnapping, but I don't think it qualifies. I don't think it legally qualifies. I don't think you can do that. So I'm going to appeal it. All right. And you're going to dismiss these other things relating to these prurient offenses. All right. So she pleads guilty. The district court sentences her to 96 months of imprisonment and 10 years of supervised release. All right. So now she goes off to appeal. All right. So at appeal, she moves to dismiss on the ground that, that wasn't a valid charge at all. I don't think you can do that. In the motion to dismiss, they argue that kidnapping does not qualify as a crime of violence under the relevant law, which we've discussed this before, right? We've discussed these problems before. If you're thinking to yourself, why doesn't kidnapping qualify as a crime of violence? We've discussed this. It deals with residual clause. It deals with Congress being really, really sloppy in their language. And every year, there's a couple of cases dealing with this because Congress is sloppy, right? So Congress named a couple specific crimes that are violence and then said, and other stuff. And we've been having to deal with and other stuff for a long time. The problem is multifold, not the least of which is in a criminal context, the law is to be narrowly construed. Because people have to know what's illegal or not, right? At least in principle, they have to know. Like the fact you didn't know is not a problem, but you have to have the ability to know, right? So if you didn't know, that sucks to be you. If you didn't have the ability to know, that sucks to be us if we're the government, right? So this is the problem, right? We're trying to determine whether or not kidnapping falls under this residual clause, which has been a major pain in the ass because Congress is lazy. Now, meanwhile, there was a Supreme Court case. There were a couple of Supreme Court cases, actually. Sessions versus Dienma and States versus Davis, which, like so many other cases dealing with residual clauses, said, yeah, not so much. They're invalid for vagueness. Again, the problem is Congress is lazy, right? Congress said these specific things qualify as a crime of Congress. And then other stuff. Wait, what other stuff? It's a criminal statute. The criminal law is to be narrowly construed. You can't just say and other stuff. So the Supreme Court, unsurprisingly, said, yeah, not so much. You can't do that. You can't just say and the other stuff. So, so kidnapping isn't one of the listed offenses. So the United States Supreme Court reached those conclusions. So as this appeal was ongoing. So as a result of the United States Supreme Court kicking the government in the teeth, the government here moved to dismiss the claim. against this person, right? Because they were convicted of a crime of violence relating to kidnapping. But it's the residual clause, and they just had their teeth kicked in. So it's like, okay, we're going to move to dismiss count 2, the thing she pled guilty to, because, we just got our teeth kicked in and we can't. So they say, okay, we're going to do that. But that's not where the government wants to stop. What do they want to do? They want to go back and charge her with the other stuff now. They want to go and charge her with the other things, the other counts they dismissed. No, I don't think so. On remand, Shelby over here moves for immediate removal from custody. Hey, counts 1 and 3, they were dismissed. Count 2, legally invalid. So why am I being held in prison? There's no legal basis for being held because, the U.S. government over here took a different view, arguing it had been relieved from its obligations because the decision against it was vacated. They want to reinstitute count 1 because the guilty plea was subsequently vacated by the motion of the defendant. So the U.S. government would like to go back on their deal. It probably seemed like a really good deal at the time, right? We're going to dismiss these sort of minor charges. I mean, in the grand scheme of charges, right? We're charging you with failure to register, which are more minor charges. Like, they're not nothing. They're not nothing, but it's something the government's going to give up because they got the big charge, right? They got the big charge. They got the crime of violence thing, 96 months, 10 years supervised release, right? We got the big charges, right? So we're going to dismiss these little piddly charges in comparison. Well, big charge just went bye-bye. Big charge just went poof in smoke. And the government's like, how about those small piddly charges? Can we have them back? Can we go back on our deal? It turns out, the U.S. Supreme Court thought our deal sucked. Can we go back on our word? We'd like to go back on our word and charge that other stuff. I don't think so, Tim. All right, so in new trial number 2, where the U.S. government is bringing back the charges from before, so they go to trial, and it's like, okay, count 2 is dead. How about count 1 and 3? So at new trial, on counts 1 and 3, these would be the things that have previously been dismissed as part of the prior plea deal, right? Shelby over here pleads not guilty, and then just doesn't offer any defense at all. So at the renewed trial, Shelby says, I'm not guilty, and says, I'm not offering any defense of any variety, because this is legally invalid. The district court found them guilty, unsurprisingly, and wound up sentencing them to the exact same 96 months, but only 5 months of supervised release, okay? So at trial number 2, the U.S. government's like, oh, we'd like to charge you with those other counts now. Oh, we're going to convict you of those other counts. Oh, how about the same 96 months? But there was a plea deal. So on appeal, they argue that they erred by allowing the government to proceed on these charges. Shelby here argues the plea agreement expressly by its own terms reserved the right to appeal. Okay? That's the kicker, right? It is not uncommon for these agreements to waive all rights to appeal. In fact, it's probably more common to include all rights to appeal. I guess the U.S. government thought it wasn't really giving up anything. Okay, sure, you appeal. You appeal that kidnapping isn't a crime of violence. Wait, it's not a crime of violence, right? So the deal included the right to appeal. So because of that, it shouldn't allow them to proceed on the dismissed charge. Shelby also argues if he can be said to repudiate his end of the bargain, he agreed to plead guilty to some other thing, which he already did, right? He already agreed to plead guilty to the other thing, but he did plead guilty, and that was vacated. So he did exactly what he said he was going to do. So, yeah, or she said she was going to do in this case. Okay, so now that we understand the framework of how the U.S. government is getting its teeth absolutely handed into it, absolutely getting its teeth kicked in to prove that, yes, the U.S. government does lose the cases, let's discuss the relevant law. How are we to interpret this thing, right? Well, plea agreements are fundamentally grounded in contract. Right? They might be a little bit special in some respects, but really fundamentally contract principles permeate. So let's go to the contract. What does the contract say? Pursuant to the plea agreement, the contract, Shelby gave up his right to go to trial. It is a he. I apologize for misgendering earlier. And holding the government to its burden of proof. Instead, pleading guilty to count 2, charging him with a crime of violence. Except it's not. He did that in exchange for the government's promise to dismiss count 1 and count 3. We construe that in light of the interest at stake. And on its face, it seems so long as Shelby lived up to his side of the bargain and entered the guilty plea to 2, the government would refrain from anything related to count 1 and 3, which is exactly what you're now saying he's convicted of, because you had a new trial. You had a new trial and everything, and just convicted him on counts 1 and 3. But you said you wouldn't prosecute him for that, in exchange for him agreeing to plead guilty to count 2, with the right to appeal. Moreover, the government entered into this agreement with full knowledge of the appeal. They agreed to it. To be sure, we will enforce plea agreements even in the face of unanticipated changes in circumstances, on the theory of assumption of risk. Yeah, that's right. You know, if the law changes, you assume the risk of the law changing. That works both ways, by the way. The government has no problem burning your ass when the law changes against you. But when it changes for you, yeah. Here, the appeal was not unanticipated. The possibility of successful appeal was expressly contemplated, as reflected in the conditional plea of guilty and the reservation of right to appeal. If the government wanted to reserve its right to pursue the failure to register charge, should the appeal prove successful, it could have done that, right? So it could have said, okay, if you successfully appeal, then we have the right to charge these other things, but it didn't say that. It said, we're agreeing to give up forever these charges in exchange for your plea. Well, he pled. It could have also required him to plead guilty to count 1 along with the conditional plea of 2, but it didn't do that either. As a result, the plea agreement prescribed that if they lost the appeal, he'd stand convicted of count 2, but if he won, you're done, right? That was the deal. Shelby says, I conditionally plead guilty to 2 in exchange for you giving up 1 and 3. Government says, okay, we give up 1 and 3. I plead guilty. He does plead guilty, but it's a conditional plea. It's a conditional plea. What's a conditional? Appeal. What's the appeal on? You can't legally do this. This is not a valid charge. Well, Shelby did everything that they said he was going to do. Shelby did everything he said he was going to do. He pled guilty. He entered the plea of guilty. He appealed. He won. In finding to the contrary, the district court relied primarily on what it saw as an absence of immunity upon remand provision. The district court said there was no provision expressly stating that Shelby could not be prosecuted for failure to register. The Court of Appeals says not so much. The fairest reading of the agreement is it does exactly that. So it might not contain that language exactly, but that's the agreement, right? That's the agreement. You give up 1 and 3, I plead guilty to 2. It doesn't say you're immune, but you gave up everything. So long as Shelby abides by his agreement to plead guilty to 2, which he did, with an express right to appeal, which he did, and with no further proviso as to what happens if the appeal is successful, which there isn't, the government promised to not further prosecute. That was your promise. If you win your appeal, we agree not to prosecute. Well, you won. And even if there was some ambiguity on this point, which there's not, the burden would be on the government to clear it up. You thought you had a clear winner. You thought to yourself, surely kidnapping is a crime of violence. How could kidnapping not be a crime of violence? Well, because Congress is really, really sloppy. That's how. Because the criminal law is to be narrowly construed. That's how. Because the residual clause is unclear. That's how. All right, so the government, having its teeth kicked in, is going to try something else. This is fun. The government says that even if the plea agreement required it to forego prosecution, which it totally did, that obligation was discharged because of frustration of purpose doctrine. Oh, okay. Right, our contract that we're not going to prosecute is invalid because frustration of purpose. Sure, let's give that a try. The doctrine, which is a staple of contract law, it sure is, provides that if after a contract is made, a party's principal purpose is substantially frustrated without fault of occurrence of the event, by which a basic assumption on which the contract was made, remaining duties are discharged, right? So basic principle of contract law, right? You have a contract to have an agreement. Things happen that are completely outside your control, that completely frustrate the purpose of the contract, discharges obligation, right? Something no one could have seen coming, right? The agreement is between you as the parties, something completely external that's not your fault has happened, that's basically made the contract basically impossible. We're going to let everyone off the hook because it's something that no one could have contemplated. Now, incidentally, you can contract around that. So if you really want to have an enforceable agreement, you can contract around that, but it is a basic principle, right? So they're going to say, oh, our purpose is frustrated. Our purpose is frustrated because the validity of count 2 was a basic assumption of the plea. We assumed that it was valid. The Court of Appeals is like, no, you didn't assume that because the very agreement itself says that you had the right to challenge the legal validity. We assumed it was legal, but you are entering into a contract on the explicit premise that they have the right to challenge the legality. The plea agreement was not an assumption it would remain valid. To the contrary, it expressly contemplates its very opposite. Perhaps the government underestimated the odds of winning. I'm sure they did. Though recent and pending cases would have made clear that the argument was substantial. Well, that sucks to be you. But just as we often enforce agreements against criminal defendants, even in the face of subsequent federal challenges of law, they sure do. So we must enforce plea agreements that may or later prove less advantageous. Right. So if the law changes subsequent to your plea in a way that benefits you as the defendant, that sucks to be you. Right? That sucks to be you. Unless the plea agreement expressly contemplates it being open or other language, right? If you make a full and final plea, and this is the law, and the law changes after that, oops, because that case is settled. That case is final. Other people in the future, but not so much for you, right? And the court will enforce this every day. They will do this every day against criminal defendants, every day, right? You plead to something, it's final, that turns out not to be a crime, oops, right? You pled, it's over. The plea was conditioned expressly on the right to appeal. You can't complain about conditions you didn't see coming when it's expressly contemplated. Here, the parties expressly contracted for the right to argue the plea did not constitute a violation of a crime of violence. The district court is then going to try to keep this valid on the basis that Shelby repudiated. So, we're going to say the contract is no longer valid because it's Shelby, you see. Shelby is the one violating the contract. That's the problem. Right? Shelby is the one violating the contract. Shelby has repudiated the contract. Shelby's in violation. And because they're in violation of the contract, they can't benefit from a contract they are in violation of, right? Basic principles of contract law again, right? You can't benefit from a contract that you are in violation of, right? You're the one creating the violation, you can't benefit. So it's Shelby. Shelby's the one violating the contract. Let's give that a try. As the district court saw it, though the plea agreement initially remained operative on remand, Shelby failed to live up to the end of the bargain when they moved to be released, instead of honoring the commitment to plead guilty to count 2, this time by pleading to a lesser included offense. So Shelby is in violation because they aren't pleading guilty to count 2, because it includes a lesser included offense. The Court of Appeals is like, nope. The premise of the district court's conclusion is that by agreeing to plead guilty to count 2, Shelby promised to plead guilty not only to the crime of violence offense expressly charged, but they also agreed to include a plea of guilty to the lesser included offense. So they were charged with this bigger offense, the crime of violence thing, right? There is a lesser included offense, a failure to register within the context of count 2. So it's like, well, by agreeing to plead guilty to the big thing, you're agreeing to plead guilty to the little thing. That means that the government argues that although big thing is no longer valid, little thing is still valid, so you must plead guilty to that. But we can find no support in the case law or in the terms of the agreement for any agreement to plead guilty to the lesser included offense as a separate promise. Nope. They promised to plead guilty to the top line offense, and that's all they promised. And this is being determined by contract law, right? What they promised was to plead to big boy offense. Little boy offense was included, but they didn't promise to plead guilty to that, and you promised to waive everything. What the parties agreed to was that he would plead guilty to count 2, which in turn, count 2, as it was provided in the agreement, was one thing, a violation of the violent crime thing. Nothing in the plea provided there's also a plea of guilty to any lesser included offense. That wasn't the promise. It's true, as the government argues, that pleading guilty to count 2, they admitted to facts for failure to register as the lesser included. And our point is not that the government's position is entirely unreasonable, but the government did not write its position into the plea agreement. So sure, by admitting all the facts, they admitted to everything, but they didn't write it into the plea agreement. And so what did Shelby promise? This is fatal to the government's repudiation theory, because any ambiguity must be construed against the government as the drafter of the agreement that waives a fundamental constitutional right. Basic principles of contract law. This is a criminal case. It's the rule of lenity. It is narrowly construed. They are the drafter of the contract, right? Interpretation goes against the drafter of the contract for any ambiguity. There is a second and related problem with the government's theory. It does get worse. It is axiomatic a guilty plea must be knowingly, intelligent, and voluntary. It sure is. If you're going to plead guilty, it must be knowing, intelligent, and voluntary. The premise of the government's argument, a promise to plead guilty to one offense includes a separate promise to plead guilty to any lesser included offense should the charged offense become legally invalid, appears to be an entirely novel legal theory. The government has pointed us to no cases endorsing this proposition, and we have found none. So there is no background law that might have alerted him or the counsel that promise to plead guilty extended beyond its own terms. Nor, as best can we tell, did anyone inform them at the plea colloquy that they were promising to enter a guilty plea to the lesser included. As described above, there is no unambiguous provision in the plea agreement either. Under these circumstances, we cannot say there was a knowing, intelligent agreement to plead guilty to count two. You just love to see the U.S. government just absolutely get its teeth kicked in. You're the ones who drafted this crap. You're the ones now trying to... The defendants do this stuff all the time. The reason this is so fun is because defendants make these arguments every damn day. The other way around. And the government makes these arguments every damn day the other way around. And the government wins all the time. Government wins all the time on this argument, right? The reason this is so fun is that the government is getting its teeth absolutely handed to them. In the same way that if they were a defendant, they were getting their ass handed to them, right? It's just that the shoe is on the other foot. You hoisted yourself by your own petard, my boy. U.S. government, you are done. You are done. So thus, it leads us only to one place. For these reasons, we vacate the conviction and sentence and remand with instructions to order release from federal custody. It's over. There is no conviction. It's gone. Release them from prison. Wow. Thus, that brings us to the end of the case of United States of America versus Shelby Petties. Shelby over here did some questionable things, to be sure. He has some history as it relates to being a prurient offender, and he failed to register and did some other things that might have done a little like kidnapping. Well, he entered a plea with the United States government. And he said, how about you drop all the other stuff and I plead guilty to the crime of violence thing? Okay, but I want the right to appeal. And the U.S. government's thinking to themselves, sucker. Well, it turned out the U.S. government was the biggest sucker of all. Because the U.S. Supreme Court, said no. Nope, can't do that. It's criminal law, rule of lenity, narrowly construed, residual clause, blah, blah, blah. Not so much with all that. And the U.S. government's like, huh? What? Surprise Pikachu face. Surprise Pikachu face. He appealed like we said he could. We gave him the right to appeal and everything, and he did, and he won. And the U.S. government's like, how about we'd like to charge you again? And then did, and then prosecuted him again and convicted him again. And the Court of Appeals is like, no. Shelby did everything he promised to do. You are the ones who wrote the contract. He made the knowing, intelligent decision to plead guilty to count 2 as you guys specified it. You didn't say it included anything lesser included. You didn't do any of these things. Nope. So, poof goes the criminal conviction, thanks to the U.S. government being really sloppy. The U.S. government gets hoisted on its own petard and enjoys the just results of its own reward. And that brings us to the end of the discussion of this case.